5 seconds to go. Start. It is the case of the appellants that the direct recruits cannot claim appointments from the date of the vacancy in their quota before their selection. It has been contended that Item 3 of Annexure A, Section B prescribes the method of recruitment in the manner in which vacancy is allocated. According to the Learned Counsel, it does not involve rota for the purposes of seniority. It prescribes only quota, therefore, rota cannot be implied. It was urged that seniority is dealt with only by Regulation 3 of the Service Regulations 1964 and not by Regulation 34 of the Recruitment Regulations 1966. Reliance was placed in this connection on Regulation 34 as amended on 15 September 1995. It was submitted that in view of the said amendments, Annexure A refers to only allocation of vacancies and not for determination of seniority. It was to be determined only by Regulation 3 of the Service Regulations. The non-availability of candidates in a particular category, it was urged, may be on account of ban on recruitment or on any other ground. Therefore, in the present case, where promotees were regularized in the promotion quota when direct recruits were not available, the quota in Item 3.1 of Annexure A will not apply. It was submitted that in any event, allocation of vacancy under the said clause was not rigid and it cannot be a basis for denying seniority to the promotees from the date of regularization. Reliance was placed on the judgment of this court in the case of Direct Recruit Class 2nd Engineering Officers Association versus State of Maharashtra. We do not find any merit in the above arguments. The appellants have not challenged the validity of the above regulations. As stated above, it has been contended before us on behalf of the appellants that Item 3.1 of Annexure A, Section B prescribes method of recruitment and the manner in which vacancy is to be allocated, which does not involve rotation for the purposes of seniority, that Item 13.1 of Annexure A, Section B prescribes only quota and rota cannot be implied. However, the appellants before the High Court unequivocally submitted that under the above regulations, promotions and direct recruitments were required to be made in the ratio of 1:1 and that the said regulations provided for a cycle in which vacancies were to be rotated. In the said affidavit, it is further submitted that in the absence of direct recruits, the slots reserved for direct recruits were liable to be adjusted with the promotees immediately and subsequently arrived direct recruits should be given their positions in the seniority list subsequently in a bunch. In our view, the averments of the appellants before the High Court, if accepted, would result in complete violation of the quota and rota rule embodied in the above regulations, which cannot be permitted. As stated above, the appellants were promoted originally subject to the conditions envisaged in Regulation 34 and therefore they cannot claim seniority by ignoring the said regulations and on the basis of their officiating services. They were promoted temporarily under Regulation 30, which provides for ad hoc promotions. Regulation 34 ensures induction of qualified direct recruits. But for Regulation 34, candidates from feeder posts would be temporarily promoted to the slots reserved for direct recruits and on their regularization, the quota prescribed for direct recruits will be defeated. Regulation 34 has been enacted to protect quota prescribed for direct recruits. As stated above, Regulation 3 of the Service Regulations has to be read with Regulations 30 and 34 of the said recruitment regulations. The appellants were promoted on temporary basis under Regulation 30 with a clear understanding that the period of officiation will not give them any right over direct recruits in future. It is for this reason that Regulation 36 states that if a temporary promotee is subsequently promoted in accordance with the regulations, his probation will commence in the higher category only from the date of subsequent promotions. For the same reason, Regulation 34 states that revertees shall be subsequently considered for re-promotion against the quota of vacancies reserved for being filled by promotion. Therefore, Regulation 34 protects the quota prescribed for direct recruits. On reading Regulation 3 of the Service Regulations with Regulations 30 and 34 of the Recruitment Regulations, it becomes clear that neither the date of promotion nor the date of selection is the criterion for fixation of seniority. The fixation of seniority under the above regulations depends upon the number of vacancies falling in a particular category. Therefore, the rule of rota is inbuilt in the quota prescribed for direct recruits and for promotees in terms of Item 3 of Annexure A, Section B to the Recruitment Regulations. Stop.